The maximum penalty for dangerous driving occasioning grievous bodily harm is 7 years imprisonment. It goes up to 11 years imprisonment where there is one or more circumstance of aggravation. It's what's called a Table 1 offence, which means it can be dealt with in the local court, or if you or the prosecution elects to do so, in a higher court such as the district court. If it does stay in the local court, the maximum penalty is 2 years imprisonment. Circumstances of aggravation are, firstly, where your blood alcohol concentration is at least 0.15, in other words, in the high range of drink driving. Secondly, where you're driving at a speed of at least 45 kilometres over the speed limit. Or thirdly, where you are driving to escape a police pursuit. Or fourthly, where your ability to drive was substantially impaired by a drug or combination of drugs. For both offences, a disqualification period will apply, and the disqualification period will depend on whether it's your first or second or subsequent major traffic offence within the previous 5 years. A major traffic offence is one that you received a court attendance notice for, had to go to court for. For example, drink driving, driving while suspended or disqualified, dangerous driving, and so on. If it's your first major traffic offence within 5 years, the automatic period of disqualification is 3 years. However, the court can reduce that down to a minimum of 12 months if there are good reasons to do so. For example, if you have a good driving record and a strong need for a licence. If it's your second or more major traffic offence within 5 years, the automatic period of disqualification goes up to 5 years. However, the court can reduce that down to a minimum of 2 years, again, if there are good reasons to do so. If it's your third or more major traffic offence within the previous 5 years, then the RMS will declare you what's called a habitual traffic offender and add an extra 5 years disqualification to your court-imposed disqualification. If you wish to plead guilty to the offence, a good lawyer will be able to push for an aggravated charge to be reduced down to a non-aggravated charge. They will be able to ask for the police so-called facts to be amended, that is, the document that's handed up to the magistrate and that the magistrate reads, outlining the circumstances. That can be amended to make the case less serious. They can push to keep the case in the local court where the maximum penalty is lower, as said, it's 2 years. And they can help you to prepare for your sentencing hearing by guiding you on how to prepare character references, your letter of apology, and directing you to a traffic offender program. They can fight to get you the lowest possible penalty in court, keep you out of prison, and reduce the disqualification period. And if it's your third or more major traffic offence within the previous 5 years, they can ask the magistrate or judge to quash the habitual offender declaration.